Good evening, ladies and gentlemen. I would like to start this Wednesday, February 8th, 2023 meeting of the Hayden City Council. It is a special meeting. I would appreciate it if Councilmember DePriest would lead us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Abby, could I please have a roll call of the council members?
Council President Roeder?
Yes.
Councilmember DePriest?
Here.
Councilmember Satterfield?
Yes.
And Councilmember White?
Yes.
As I'm sure all of you folks know, our reason for being here tonight is to discuss Stone Creek North. I'd like to thank you all very much for showing up. I think this is a good indication of the interest that Stone Creek North has. Yes, ma'am.
Speak up just a little bit more, please.
I sure can. And I wonder if, Michael, if you're listening, could you perhaps try to turn the microphones up? I'll try speaking up a little bit louder regardless. Thank you. I would like to tell you folks the order of the things that we will have tonight. And yes, and if any of...
Sorry about that.
No worries. We're good.
Yeah, the hearing assistant is available.
Okay.
Okay.
He's watching.
Can you hear now, Rick? Yeah. Good, okay, good. All right. I'll provide an initial welcome. At that point, we're going to ask our city attorney to go through the process, where we're at, and why we have parameters. We actually have sideboards about what we can do tonight. Afterwards, I'm going to ask our Donna, what is your title? Thank you very much. Community Development Director Donna to go over several PowerPoint slides that she has concerning where we're at, where we came from, and where we're at. I will then read the questions and answers. As you will find out, there is a reason that I am reading these questions and answers. At that point, we will allow any follow-up questions that you, ladies and gentlemen, have. Now, when we do the follow-up questions, because we are not in a public comment phase of this discussion, and Fonda will tell you about that more, we ask that you have only questions instead of comments. Please ask only questions not already asked and within the parameters that we're talking about right at the beginning here that Fonda will get into. If you raise your hand for a follow-up question, please go to the podium and state your name and address. At that point, I'll have a final comment to close the meeting. We have only a couple of rules here tonight, ladies and gentlemen. First of all, everyone will treat everyone with respect. I have no time for anyone that is disrespectful. Second, if you would please mute your cell phones, I would appreciate it. Rather than have this, we seem to have a couple of those every meeting. Fonda, can you provide some background for us where we're at in the process and why we need to put sideboards on our meeting tonight?
You bet. Thank you, Mr. Mayor. And I'll stand. It'll help me speak louder, and then maybe some of you hear a little better as to what's happening. So I'll give you a little bit of history. I'll try not to talk too long. We have many questions that I know you want answered, but I think it's important for those of you that haven't been to a previous city council meeting where we've talked about this to understand where we're at and why we're here. I know there was some concern after the last meeting as to why the mayor indicated that we would only be answering questions in relationship to the existing record. So I often tell the council or any council that I'm working with, the lovely part about being a council member is you can effectuate change. The horrible part about being a council member is you inherit all of the decisions of previous council. And so oftentimes you don't have a lot of wiggle room with relationship to decisions that you've inherited. And this is kind of a perfect example of that. And it's not saying that the previous council did anything wrong. It's just saying that they are the recipients of a decision that's already been made as far as the preliminary plat goes. And so for a little historical context, the Idaho Constitution provides that zoning issues for cities are considered a police power. And I'm going way back because I'll bring you quickly to where we are right now. And that police power then is left to your governmental entities, your municipalities, to create process and expectations with regards to zoning and land use. So after that police power was given by the Constitution, along came the Local Land Use Planning Act in 1975. And the Planning Act said, not that it is your responsibility, but you must do it. So if any of you go and read cover to cover Title 67-65, that's our Local Land Use Planning Act. It's a great read if you're ready to go to bed and you want to doze off and pick it up again in the morning. But there's some good stuff in there because what it says is, cities, this is your responsibility. You need to create ordinances and you need to create code related to how the properties and the property owners within your boundaries are to divide their land, are to use their land. Basically, all the land use regulation is left to the governmental entity, and that's why you have Hayden City Code, and the land use section specifically. And if you look at Hayden City Code and you compare it to Coeur d'Alene City Code, and you compare it to Post Falls City Code, and you compare it to Rathdrum, you'll notice that there's a lot of differences in there. And that's because this governing board has authority to set the land use regulations for this city. They don't have authority for Coeur d'Alene, and Coeur d'Alene doesn't have authority for you. And developers get frustrated with that. Trust me, we hear it. Why can't we do that here? We can do it in Post Falls. Well, it's because we have our own code, and we are bound by Hayden City Code, which we're required to have under the Local Land Use Planning Act. And to go one step further, Coeur d'Alene gave us a great Supreme Court case in 1984. And what happened in 1984 is the Coeur d'Alene Council decided that they wanted to try and put initiatives out to the voters for zoning decisions. And the Supreme Court came back, and Idaho Supreme Court came back and said, no, zoning is the responsibility of your governing board, and you cannot put it out in initiative form on elections. So no zoning issues go out to election on initiative in the initiative form. If you've ever wondered why, it's because of that Supreme Court decision. So when we get to our Hayden City Code, and what does a developer or an applicant, we'll just call them an applicant because they're just landowners, what do they need to do to develop their land? It comes in a variety of different forms. This application happened to be an application for a preliminary plat. I'm going to warn you, you're not going to like my next words. A preliminary plat is what we in the legal planning world call a matter of right application. And what that means is, as long as they meet all the elements of our code, we don't get to tell them, no, they can't subdivide. Now, I'm not talking about a preliminary plat that comes in coupled with a zone change or a variance or is wholly separate from that, a conditional use permit. We have a subdivision code as we're required to have, and as long as this application comes in and it meets the elements of our code, then it goes to the next part of the process, which is outlined in our code as well. And that process is the whole due process section. And that's where that preliminary plat application comes in front of planning and zoning for a public hearing. That public hearing is called a quasi-judicial hearing. Why is it quasi-judicial? Because the planning and zoning commissioners are sitting in the context of judges. So they can't have ex parte communication with you. They can't talk to you about it. They can't have a conflict of interest. They can't be receiving any financial benefit or economic interest from this application in any way. And they can't be biased. So they need to come in and provide a fair, now we have to not make comments. They need to come in and provide a fair and impartial board for this application to go to, because the entire design of the process is to protect due process rights. Due process rights of the applicant, due process rights of the affected persons. And you will hear me say affected persons a lot, because not everybody in the city could go file an appeal on an application that they don't like that's been approved. They don't have standing. And there's a legal definition of an affected person, and generally it's the people who live within 300 feet of the property in question or the application in question. So our appointed officials, our Planning and Zoning Commission, and our elected officials, our city council, are both on the hook and responsible for providing what we call this quasi-judicial hearing. And my job, and they've heard me say this before, is I don't care what their decision is as long as they follow the process and they've deliberated well. And by deliberating, that means you take the facts that you receive in this public hearing and you apply those facts to the standards of approval that have been outlined for this application. You guys, if you've been here before and watched Donna give a presentation, you know at the end when it comes time for deliberations that the standards of approval are put up on the big board, and that's where the council members or the planning and zoning commissioners are responsible for taking the information they've heard and then making a decision regarding those standards of approval. Quasi-judicial is quasi-judicial because it affects specific individuals' property rights. And that's why due process is required. Due process meaning an opportunity to know what's going on. That's why you all get noticed. An opportunity to be heard. That's why you have the ability to provide written comments or come to the public hearing and make comment. I know I've heard a lot of you get frustrated because you feel like your comments aren't heard. These guys are hamstrung by the fact that they can only apply. They can hear you and they can feel you, but they can only apply the words that you say that are in relationship to the standards of approval when it comes to making a decision. And that process for this particular application already happened. So the other aspect of due process rights is once the final written decision was approved by City Council for this preliminary plat, there was a 14-day window of opportunity for a request for reconsideration to come back to this council. And then after that expiration, had that reconsideration either been denied or allowed or whatever happened, then there's a 28-day opportunity for an affected person or the applicant to go in front of district court and file a petition for judicial review. Once those appeal periods expire and the conditions of approval are approved by City Council, then staff's direction and the code requirements are they move into what you hear us call the construction phase. You may think that's construction of homes. It's not. It's construction of infrastructure, because between preliminary plat and final plat is going to be all of the public improvements. Our job at final plat, what this council does at final plat, is they say, yes, the roads were put in the way we asked them to put them in. Yes, the sewer's put in the way we asked it to be put in. Yes, the water's put in the way we asked it to be in. And they accept that public infrastructure. That's their job. At final plat, they say, okay, you developer, you put in the infrastructure we required of you, and now we're going to accept that infrastructure. Only after the final plat is recorded are parcels created and can homes be built and building permits issued. So I know that's probably a long-winded explanation, but some of you may have not ever heard that. Once those appeal periods after the preliminary plat have expired, they're in construction phase. So that is then they have to meet those conditions of approval. There's not a window of opportunity there for a public forum. Why? Because then the applicant's due process rights are violated. And I know that is not what you want to hear, but that's where we're at right now. There may be windows of opportunity, and we want to answer, and we are going to answer all of your questions tonight. I just want you to know that the questions will be answered. But in relationship to why isn't this a public comment time, it's because the public hearing process is closed, and it's been closed for a long time. And so that's why there's parameters around this meeting tonight. That's why we have to make sure that we protect. It's my job to make sure that we as a city, we are all the city. A lot of you put in letters, the city did this, did that. No, we have faces. Donna, Ellen, Rob, Mayor, Brett, myself, we have faces. We are people. People are making decisions and are moving things forward because we have a process that has to be followed. I know in this process that we've been accused of being too strict. Well, guess what? if it was you applying for a subdivision of your land, you would want the exact same treatment. You would want me to make sure that the advice I'm giving to these guys means that we are doing the best we can to protect the due process rights and the property rights of everyone involved. If you're going to hear some answers tonight that say this is a civil matter, because there are parts of your questions that the city has no say in. We have no dog in some of this fight, and some people don't understand that. So you do, any one of you, have the ability to hire legal counsel and get your questions answered on the questions that we say it's a civil matter, because I can't, on the city's dime, be advising you individually. So I wanted to just tie up some of those parameter pieces for you before we start. And like I said, we had a inclination to take all the questions and kind of lump them into topics. We did not. Every question will be answered tonight. So I hope that clarifies the parameters of the process.
Thank you, Fonda.
You're welcome.
Donna, you have some PowerPoint slides for us.
I always get to be the guide one.
Oh, great.
So, couple other things that I wanted to kind of touch on is in relationship to the questions that were asked.
Donna, could I stop you for just, can you folks in the back hear her?
Louder.
Give me a thumbs up or thumbs down?
Okay,
Down, okay, if you could speak.
I'll get louder.
Thanks.
sorry. Sometimes I talk too loud, so. A couple of things that I wanted to talk about is the first one is during the public hearing process, the very first thing that we do when we get an application for any land use action is we notice between 27 and 33 agencies that could potentially have comments about a certain project that's coming forward. And then when we get comments back from those agencies, if those agencies talk about another agency, we reach out to that agency if we didn't get comments from them to try to get them to provide comments so that we can include those as part of the record and we can address those in our presentation and in the analysis. And so we can only reach out to agencies if agencies don't provide comments back. They aren't a part of the record and we can't require them to become a part of the record. So that's the first thing I wanted to point out. The second thing I wanted to point out is that we saw lots of comments in the questions, kind of leading up to the question, in relationship to a variety of the maps or how things seem to change over time. And so in response to that, I wanted to pull up 4 documents that had been presented in a public forum as part of this project. The first one is just an aerial image of where this project is located. This project is located north of the existing Stone Creek. Stone Creek subdivision came in as Rocking R North under preliminary plat, and at the time of final plat was platted as Stone Creek, just FYI. And Stone Creek and Stone Creek North preliminary plat was part of an annexation that all happened at the same time. And at the time of annexation was envisioned to all develop at the same time. For a variety of reasons that didn't occur, but it's all part of that annexation. All that information was referenced in the staff review, which was all on the city's website at the time that the first public notice was noticed. So in that staff review for the first public hearing before Planning and Zoning Commission is the map on the left, this map. Oh, there's a mouse. This map is what was in the staff review and what was provided as the initial public comment for the initial public hearing. And as part of that public hearing process, it was identified that the applicant wanted to have a ingress egress to the north that was an emergency access road only. However, as part of the Planning and Zoning Commission's recommendations to the City Council, the Planning and Zoning Commission recommended that that not be a ingress egress for emergency use only, but it actually be a full-fledged public road built to public road standards. And so as such, between preliminary plat, public hearing, and the time that it was heard before the City Council, the applicant went back and drafted a conceptual of what that could potentially look like. That's the map you see on the right of the page. So there was some changing. In the first map, you see lots along the rim, and in the second map, you don't. And so when this came forward to City Council, and you'll see in the written decision and the conditions of approval, it recognized that there was going to be some switching around of lots and park land because of the potential of moving the road and what that road movement, in order to meet the other conditions of approval, would potentially cause to occur. For example, Northern Lakes Fire Protection District and the city of Hayden require that you can't exceed a maximum grade of 10% in grade. And so then in order to get that grade so that it's not really steep and you don't exceed that, you have to shift things around. They aren't solid based on these two conceptual plans. And that was identified in the conditions of approval. It's also identified in the Hayden City Code. And then one last one, and I only bring this one up because I was seen a couple of months ago before the council. This is out of the not completely approved construction plan set at this point in time, but pretty close. It does show how the movement has kind of morphed to make things potentially fit and work. There have been comments related to that. So the only thing I do want to point out here is that if you go back and look at this plan, there are lots that are adjacent and west, and there are some lots over here, mostly parkland and mostly parkland, but again, shifting road gives you parkland still in generally the same location and lots in generally the same location.
So the only thing I would add that as we go into the reading of the questions and answers is that the record, the current record right now, you heard me mention at the last meeting, we're confined to the record that exists. So that starts at application and it ends at the execution of the master development agreement. And the reason for that is if somebody would have appealed after the preliminary plat approval, after the written decision was finalized by council, we have a closed record at that point that goes to district court. So we have an identification of what is the record that would have gone to the court under a petition for judicial review, or also known as an appeal. And so this record is bookended at the application through the master development agreement. Then they move into construction phase, and then all of what happens during that phase and the completion lands at city council at the final plat, period. But this record right now goes through master development agreement. The written decision, I can say that.
That's all I have.
Thank you, Donna.
So the written, just so you know, the written decision for council was November 18th of 2020. And it looks like the master development agreement was finalized that following week. Just so we're talking about late 2020, so that you all have a reference for time.
Well, we've got a bunch of questions. Can everybody hear me? At the back, give me a thumbs up, maybe. You guys can hear? Okay, great. We've had many people ask questions. I'm just going to run through them. The only input that I will not read were comments that were under the guise of questions. We cannot accept comments. The rest of them, let's get into it. It's a long list, ladies and gentlemen. How many lots are platted for this development? At preliminary plat, the city council approved 72 lots. What is the average lot size in Stone Creek North? The preliminary plat request shows lot sizes ranging between 0.2 and 0.8 acres in size. The adjusted plat, based on planning and zoning recommendations, which includes that through road, shows lot sizes between 0.21 and 0.54 acres. What size will the green park space be? The required park area is 5.05 acres. Who is the developer? Seven Lakes LLC. Is the only access to Stone Creek North via Rocking R and Maroon Creek? No. There are actually 4 access points for future connectivity. In the early phases, there are 2, Rocking R and Maroon Creek. As this phase continues moving forward, there is one up through the development to the north that most of you probably know is called Marks Ranch. There is also another connectivity point in the northeast corner of this subdivision. What is the plan for runoff from Stone Creek North? How will the water be routed? That is contained in the construction plan review, and I will get to more specifics on that question later. Will the city absorb all costs to repair or replace the road condition of Rocking R and Maroon Creek due to the construction weight and traffic? State and city code do not restrict on-roadway construction traffic vehicle use on any public road. The city tries to maintain all public roads to the same level. This practice applies to past, present, and future developments. However, if specific road damage is attributed to the developer, yes, the city will require that that damage be repaired.
Mayor, may
No,
will your questions be in writing to us?
yes, oh, thanks, no, that's no fault. Thank you. Yes, the city will provide on our website answers to all the questions that I'm talking about tonight, so you folks can reference them later.
Mr. Mayor?
Thank you very much. Yes,
No.
ma'am. Oh,
As
see?
they will hear, there are a lot of duplicative questions. We're being respectful in answering them all. We will then lump them together into topics for a fact sheet for the website.
With due respect, questions have nuanced languages that cause it to be different from person to person. So even though it may be a common topic such as wetland, it's asked in a variety of different ways that have different nuances that are important for us to understand.
We will make sure that if there's a differentiation, that those questions are answered separately. You'll just
make that determination, or we will.
There's just some questions. When we finish, you'll hear that there are some that are just 100% duplicative. We'll still catch the essence of every question.
Will there be an entry point into the development from Lancaster? Yes, there will. It will not be in the early phases of development, but there will be an entry point from Lancaster. Does the Hayden City Council have an impact report regarding the wetlands for the public to review? A second question, does the impact report indicate any possible water or foundation damage to the homes east of Maroon Creek? Question 3, does the Hayden City Council have an impact report regarding the development of homes on top of the aquifer? We couldn't answer that question, ladies and gentlemen. An impact report is too broad a phrase for us to be able to answer that question. Donna, if you can help me with this, I believe that in certain required state applications, there is something that is called an impact report, but that really does not apply to this. Okay. All right. Thank you.
All required reports for this application are included in the record.
Okay. Does any impact report give any indication of possible contamination to the aquifer? No. Does any impact report give any indication of water or foundation damage to the homes located on the north side of Gravelstone Court because of the increased weights of homes built on top of the aquifer? Again, we don't know how to address that question. How quickly will the roadway in our neighborhood be repaired because of the heavy equipment traveling upon them to develop Stone Creek North? Again, state and city code does not restrict on-roadway construction traffic vehicles on use of any public road. Rephrased, our city streets are designed to withstand construction traffic. The city tries to maintain all public roads to the same level, and this practice applies to past, present, and future developments. Has the sheriff and fire department been kept informed and provided input while this development is still in the planning stage? Yes. Additionally, the Northern Lake Fire Protection District is still involved through the construction plan review and the final plat review, and those reviews are still ongoing. Why did the city not protect the wetlands as part of the Stone Creek North Development Plan? Why won't the city propose a revision to the construction design to protect the wetlands? Where will the water go if you allow the development plan to continue as designed? The Army Corps of Engineers' determination was that these wetlands were considered to be non-jurisdictional wetlands. In accordance with the first Idaho Department of Environmental Quality response letter, a request for a combined permit was received. However, as a result of the Corps of Engineers' determination, that was withdrawn. Staff reached out to various agencies to include, but not limited to, Idaho Department of Water Resources, Idaho Department of Lands, Idaho Department of Environmental Quality, to verify if indeed there were no requirements of the developer in this area. Additionally, staff asked comments from these agencies with respect to this project request. The answer was that they did not have any additional comments except Idaho Division of Environmental Quality, which reviews the construction plans as part of the construction plan review. That is ongoing. Those entities from the state and Army Corps of Engineers who have jurisdiction did not provide any additional requirements related to the wetlands to be required in the conditions of approval. Construction plan review shall be in accordance with the Hayden City Code, policies, and standards and the conditions of the approved written decision. What happens to the Stone Creek North development if it does not receive approval from all regulatory bodies as outlined in the development plan, i.e. fire district approval? No construction of this project can begin until the conditions of approval have all been met. Has the Rocking R Road extension into Stone Creek North subdivision changed from what was initially approved by the city and council? If yes, how? What traffic impact studies or additional information was considered as part of the approved change? The preliminary plat request, as you've seen from Donna's slides there, was for an emergency access road. The Planning and Zoning Commission said no. They requested that it be a full public road. The applicant provided both options at the city council. The city council approved the public north-south road to be constructed to the city of Hayden and Northern Lakes Fire Protection District standards. Have additional building sites been added to the master development agreement since it was approved by the city council? If yes, how many? If yes, what was the process that allowed this to occur? Answer is no. The city council approved the preliminary plat containing 72 lots. Various iterations of the preliminary plat have included less than the allowed 72 lots. The developer may create less than 72 lots, but may not exceed that number. Nothing in the minutes from city council or in the written decision shows any approval for less than 72 lots. The number of lots identified on page 1 of the master development agreement, was an error. Has the public park design been altered or changed since the MDA was approved by the city council? If yes, how? Will there still be a public park in the Stone Creek North development? If so, where? Yes, there have been changes. It is shifted in location, but is generally in the same place. The master development agreement and the annexation agreement, which occurred years before this, requires a 5-acre park. As a result of the City Council's decision to provide a full public road to the north, as well as the decision by the City Council to not have the park along the western boundary of the subdivision to the north, those were both factors in slightly modifying the location from that shown to the City Council at the time of the public hearing. The staff review recognized the unique characteristics of this area and identified this park to be a specialty park in accordance with the park master plan. Per the Master Development Agreement, Exhibit C, Conditions of Approval, has the second emergency vehicle ingress-egress through the Marks development to Lancaster, as described in the 2020 City Council Conditions of Approval, been satisfied? What happens if the developer is not able to get a right-of-way for this purpose? The preliminary plat identifies 4 locations of ingress and egress. One to the north, one to the northeast, one to the southeast, and one to the southwest. The right-of-way for the entire roadway would be dedicated at the time of the first plat. That includes the right-of-way north to Lancaster. Councilmember Panabaker noted that the completion of the road to Lancaster would occur with the Marks subdivision to the north. That's coming from City Council meeting minutes. Should the development proceed as outlined in the current master development agreement, what, if any, consideration has been given to addressing the traffic impacts and pedestrian safety to surrounding neighborhoods and roadways that are experiencing overwhelming traffic numbers and vehicles traveling at unsafe speeds, specifically on Maple, Lacey, Buckles, Wyoming, and eventually Rocking R? And how does the city plan on paying for those type of improvements? Existing conditions within surrounding neighborhoods is not caused by the development of this proposal. The city's impact studies and fees are expressly restricted from addressing existing deficiencies. Per the transportation analysis required as part of the submittal of this application, the developer is paying an additional amount for transportation impacts over the impact fee amount collected at the time of the building permit issuance. How will the streets be configured in the new development? This questioner referenced the narrow width of the existing Hurricane Drive. The streets shall be configured to meet the City of Hayden codes, policies, and standards and be in compliance with ST 111 and ST 111A standards for local street section. Roads shall intersect at right angles or within 10 degrees of perpendicular. Intersection curb radii and the minimum horizontal curvature shall be reviewed at the time of the construction plan review. If it is determined that revisions are required, the subdivision may be affected. All required street improvements shall be in accordance with the current city standard drawings and ADA compliance, including the proposed bike and walking pathway, pedestrian ramps, sidewalks, stormwater facilities, etc. Street rights-of-way shall be of sufficient width for maintenance of embankments and cut slopes. Will there be a street exiting to Lancaster or Strayhorn? There will definitely be one going to Lancaster. Strayhorn is yet to be developed. That crosses to the east of Stone Creek North. Will these homes be the same design as what is in the Stone Creek area? Home design is not required or reviewed at the time of subdivision. This is not a planned unit development, and therefore, we have no code to define any architectural design requirements. If the development is unsuccessful in mitigating flooding from heavy stormwater because the wetland was built over, Will the developer be held liable for damages 5, 10, or 20 years after completion of the project? This is a civil matter. The approved stormwater management plan provides that the acceleration of the stormwater is no more than the existing undeveloped subdivision area. Let me rephrase that. Is no more for the developed subdivision than for the natural state when compared to a 25-year storm event. Could the individual developers protect themselves from future litigation by dismantling the current company and reforming another company in the future? Again, that is a civil matter the city has no control over. Who do we sue if the dynamite cracks our walls and any damage to our houses? Again, this is a civil matter. The city is unable to provide any legal advice in this situation. How many trucks per day do you anticipate going up and down Rocking R? We don't know. State and city code do not restrict on-roadway construction traffic vehicles on use of any public road. Could they use a road cut to Lancaster to go in and out? This property does not have frontage access to Lancaster Road. Our city invites the developer of Stone Creek North and the developer of Marks Ranch to the north to work together to construct a temporary construction road from Lancaster to Stone Creek North, but we cannot require it. Are the roads rated for this heavy equipment that will be going in and out? Yes, the roads are rated for on-road construction vehicles. How can you build houses over wetlands? In this situation, all of the city building and site plan requirements and building codes would be required to be met. How many houses are they planning to build? The preliminary plat was for 72 lots. How long will it take? If it is the subdivision construction, the phase subdivision has 5 years to final plat the last phase and ask the city council for an extension. If it means how long will it be until the last home is built, the city has no control over lot sales after the final plat of their development timelines. Who do we sue? You're going to get, Who do we sue if flooding takes place as a result of the plan you approved? Again, that's a civil matter. It seems that they will have only one way at present for ingress and egress. Is this legal? Ingress and egress access points are reviewed by both the City of Hayden and the Northern Lake Fire Protection District. Even in the first phase, there are 2 points of access. Does the fire department have all the required clearances required by law? Northern Lakes Fire Protection District provided comments and conditions for approval of this project. Their review of the construction plans and final plat are ongoing. In other words, we have not heard from Northern Lakes Fire Protection District. Will the city be policing the noise and dust levels during the grading and explosions? Yes. What safety precautions will be put in place? I'm sorry, we can't answer that. The question's just too broad. If the Hayden City Council doesn't have any legal recourse to change or stop the Stone Creek North subdivision project, why do the developers have to ask the city to approve their plans or plat and to change their plans or plats? The approved plans are memorialized in the conditions of approval and the master development agreement. If the applicant wishes to change those conditions, then the city must approve any change. Should the developers propose changes to be in conflict with existing approvals or city codes, then those need to be reviewed and determined by city council. If the Hayden City Council can reject or approve the plats or plans, Can it propose legally binding changes on behalf of the voters to the Stone Creek North developers? If so, why hasn't a compromise been offered that the wetlands may be parceled into combined ownership lots with space to build a home, but the wetland would not be filled in and built upon, but maintained as a wetland for the benefit of all? The city cannot require changes or cannot require changes to conditions or approvals that have already been vetted through the public hearing process and that are already identified to be consistent with the existing approvals and or the city codes, as Fonda explained a little earlier. As this project proceeds, what opportunities will be available throughout the project for public and citizen comment, status reports, etc.? Will those opportunities be proactively communicated to the public prior to the opportunity for comment? As Fonda discussed before, development of the site had many opportunities for public input, as was identified during the time of annexation, which were 2 public hearings, and at the time of subdivision, 2 public hearings. There is no requirement in the record for allowing additional opportunities for public comment. We are past the time of public comment on this project. What is the recourse and what are the real-time remedies available to the city and residents to hold the developers accountable for compliance to codes and following the master development agreement? The city's recourse is the enforcement of the master development agreement and the city code. Residents' resource is a civil matter. What process, checks, and balances will be utilized by city staff for appropriate oversight and to ensure compliance with the codes and with the MDA, the Master Development Agreement, I'm sorry. Again, city staff is responsible to ensure that the developer adheres to Hayden City Code and the Master Development Agreement. Have there been any studies to determine the impact on the greater aquifer and a code compliant mitigation plan to ensure water quality level will be maintained and the greater aquifer not harmed? Agency notices were sent to, Donna, how many agency notices did you send out again? You said 27?
I couldn't tell you how many were sent out specific to this request. I said we generally send out somewhere between 27 to 33 plus.
Thank you. Agency notices were sent to regulatory agencies, and those with comments were provided as part of the record. Will the primary ingress and egress for the subdivision and emergency vehicles be from Lancaster, Rocking R, or Maroon Creek roads? There is no primary access for the subdivision, but all road connections could be considered primary. Will there be immediate repair of any damage done by construction traffic to Rocking R and Maroon Creek streets? How will daily compliance of construction traffic be monitored vis-a-vis road damage, weight limits, and resident safety during the project? Again, state and city codes do not restrict on-roadway construction traffic vehicle use on any public road. The city tries to maintain all public roads to the same level. This practice applies to past, present, and future developments. Why is the density of lots and lot sizes that border Stone Creek's northern border allowed? Stone Creek and Stone Creek North were both annexed under the same annexation ordinance and agreements, which allowed for an overall density of no more than 2.5 dwellings per acre. Both Stone Creek and Stone Creek North are within the single-family residential R1 zone designation, which allows for a minimum lot size of 8,250 square feet. These are the maximum and minimum requirements for both subdivision areas. How is the proposed green space and park plan consistent with similar Hayden subdivision green spaces and parks? How will access for mobility impaired citizens be assured? staff review identifies the park as a specialty park, recognizing its unique terrain as one of the benefits of this park area. Portions of the park will be ADA accessible. Pedestrian and bicycle path connectivity between Stone Creek to the south and the pedestrian bicycle pathway south of Lancaster, in other words, through Stone Creek North and through Marks Ranch, is identified in both long-range plans. Why has the city chosen to ignore fish and wildlife wetlands that filters the water into the aquifer recharge area? This is not true. In no way, shape, or form has the city ignored identified wetlands. The city contacted all agencies that regulate wetlands and received 0 conditions or requirements related to these wetlands. If the question actually relates to the Idaho Fish and Game letter rather than the U.S. Fish and Wildlife Service, the city has incorporated all of the recommendations of specific language that will be included in the CC&Rs to be recorded at the time of the final plat. These requirements are captured in condition number 20 of the written decision. Does the city understand that all of the residents from this new project will be pouring fertilizers and other contaminants into the stream that runs behind homes in Maroon Creek Drive? And does the city understand that this water empties directly unfiltered into the aquifer? There is nothing in the public record that can substantiate any of these situations. In addition, we are certain that the homes along Maroon Creek Drive are doing the same thing. Has the city completed an environmental impact report about the stormwater and residential water entering the aquifer? If so, please make that report public and help us understand why you are choosing to ignore the wetlands and the aquifer. Idaho Department of Environmental Quality did not ask for an impact report. We depend on these other agencies to give this information to us and make the requirements. I would like to know if Rocking R Road north of Buckles is planned to be used as an access road for new construction. I remember that building new access road from Lancaster was previously discussed. Yes, that road is available. It's a public roadway, which is an access into the future subdivision per the approvals. Again, the city would invite the developer of Stone Creek North and the developer of Marks Ranch to the north to work together to construct a temporary construction road from Lancaster to Stone Creek North. But the city cannot require it. May I receive a readable copy of the current plat for the project? Yes, you can. All you need to do is make a public records request submitted to our city clerk, Abby Sanchez. We will provide that for you. Will there be public ingress and egress to Lancaster Road from this project? If so, when will it be in place? The beginning, the middle, or the end of the project? The public right-of-way to the north boundary of Stone Creek North is required as part of the first plat. That does not mean the road has to be constructed then. Construction is not required until the phase with that road is construction. The phase numbers are only used for identification and not for specific time of construction. Please explain how there are now more lots than the original request without being on any planning and zoning or city council agendas. As I explained earlier, the preliminary plat request was for 72 lots. Why is the city council allowing a development upon a drainage area for the nearby wetlands? It seems the initial plans for this development has changed many times since the initial submission without approval. No agencies required protection of these non-jurisdictional wetlands, and therefore it was not included in the conditions of approval. The preliminary plan request was for an emergency access road. The Planning and Zoning Commission requested it be a public road. The applicant provided both options at City Council. City Council approved a public north-south road to be constructed to City of Hayden and Northern Lake Fire Protection District standards. Why has the Stone Creek development continued on a wetlands area? We should be protecting our water supply and drainage areas. Again, no agencies required protection of the non-jurisdictional wetlands, and therefore it was not included in the conditions of approval. Why isn't the developer shouldering the responsibility and associated costs to do impact studies? You have enough documented evidence that needs to be done before the project moves forward. The developer has paid for all the studies required as part of the conditions of submittal and/or the conditions of approval. Regarding a January 10th, 2023 letter, we have not received your responses to our letter. Do you plan on addressing our concerns? We believe that all of these questions have been addressed within the context of the questions identified here tonight. Regarding the 14-day appeal, is there a statute that addresses the 14-day appeal timing and the requirements for major subdivisions? If so, please provide the references. The 14-day appeal period is included in the city's general process steps document for minor subdivisions, steps 3B and 3C. We do not see this step in the major subdivision process. Also, Hayden Code 12-5-6 appeals is under minor subdivisions. The miscellaneous code updates were completed in April of 2021. Appeals can be found in Hayden Code Section 1-1-5. Reconsideration of City Council decisions can be found in 1.1. Both identify the 14-day requirement. Regarding the Master Development Agreement Exhibit C, Exhibit C that we received through the city request for public records is not signed. Is there a signed Exhibit C? If so, please provide the updated Exhibit C. We will be happy to provide that through a public records request with our city clerk. In the August 16, 2022 Stone Creek HOA meeting, Mayor Purcell stated that he could not answer a resident's question about building on the wetland because at that time there was no approved development plan. The latest construction documents received from the city via request for public records indicate building lots over the wetlands, as did all previous submittals. Please answer our residents' question. Will homes be built over the wetlands, and why is the city allowing this? Should the subdivision be completed as proposed, residential building lots will be constructed over remediated non-jurisdictional wetlands. No agency provided a requirement to protect non-jurisdictional wetlands. In the August 16, 2022 Stone Creek HOA meeting, Mayor Purcell, that would be me again, stated it is too late for the city to require a wetland study. City of Hayden Code 12-3-4A, subsection 19 and 2, states that the city may require the developer to prepare additional studies as part of the review process. According to information received from the city, it is our understanding that the project is still under review and has not been approved. Why is the city not applying the reference city code to the developer? No agency provided a requirement to protect the non-jurisdictional wetlands. Therefore, conditions of approval do not require it. There are at least 25 building lots planned in mapped wetlands in a flood zone. The wetland is an important component to the natural stormwater system. Why didn't the city exercise its statutory authority to require the developer to study and protect this sensitive area? and require a downstream analysis of the stream that affects 30 residential properties in our respective HOAs. No agency provided a requirement to protect the non-jurisdictional wetland. Additionally, no agency identified in this area to be within the flood zone. No agency identified this area to be within the flood zone. Specifically, the FEMA map. FEMA is the Federal Emergency Management Agency. They deal with hurricanes, floods, tornadoes, etc. Their map shows 8 residential lots in the city of Hayden that are in floodplains. All of those lots are at Honeysuckle Beach. None are anywhere else. The 100-year floodplain elevation is not filled in on the checklist. Is the city willing to approve building homes and streets over the wetlands? Again, no agency replied a requirement to protect these non-jurisdictional wetland areas. Is the city willing to approve a non-conforming storm water design over poorly infiltrating soils in a flood zone, thereby risking the safety, health, and welfare of new residents and existing residents downstream from this site? Stormwater design must comply with Hayden City Code Title 8-3 and the conditions of approval. The stormwater plan must be approved prior to construction plan and has been reviewed by multiple civil engineers. The city has approved a stormwater management plan final for this property. The stormwater management allows no more water to leave the site in an undeveloped state than it does in a developed state, based on a 25-year storm event. Guy could die of thirst up here. The MDA 2.2, final plat approval states, application for final plat shall be made to the city within 2 years of preliminary approval by the city council. Application for final plat approval for the last phase of a page 2 of 2 phased subdivision shall be filed within the 5 years after the date of city council approval of the master development agreement, which approved the entire subdivision in concept unless extensions of 1 year have been applied for. Has time extension been granted by the city council? This answer is going to throw a lot of code at you, and you may want to look at it on the website. 1.2 term identifies the length of the phase subdivision to be 5 years or until all land in the project is subdivided and or otherwise developed in accordance with the terms of the agreement, whichever comes first, unless earlier terminated as provided therein, or the time of filing an application for final plat approval has been extended as provided in in Hayden Code Section 12-3-4. Nothing in this section is intended or shall be construed to supersede the city code relating to the time of final plat application from the date of the subdivision approval. I'm reading right now from city code. 2.2 refers to the timeliness of the final plat submittals and is referenced in Hayden City Code Chapter 12, Title 12, Chapter 4, which identifies what needs to be included in the final plat application. 12-3-4G identifies the approval duration as identified in 2.2 in the MDA, but also lists an exception as provided for in subsection I3 for phasing of subdivisions. The extension is requested at the end of the 5 years and not in the middle. Next question. MDA Exhibit C, written decision, page 12 of 14, bottom of page. In accordance with Hayden City Code 12-3-4F, the City Council finds that when the above conditions have been met, The applicant will have demonstrated to the satisfaction of the city engineer that all existing and proposed infrastructure meets or can be constructed within 2 years after the date of city council approval of the master development agreement, which approved the preliminary plat to meet the following standards. How did a single-phase 2-year project approved by the city council change overnight to a 5-year multi-phase project with the execution of this master development agreement? The standards of approval at 12-3-4 at the time of this proposal identified that the proposed infrastructure meets or can be constructed within 2 years after the date of the city council approval of the master development agreement. However, this does not determine the actual expiration of the project term. This project was submitted from the start as a multi-phase project and therefore has a 5-year term. Did the developer file for final plat application within the 2 years after the date of city council approval of the MDA in accordance with Hayden Code 12-3-4G and consistent with the Master Development Agreement 2.2? Yes, as they are a phased subdivision and shall comply with the exception identified in 12-3-4G, which addresses phased subdivisions in accordance with subsection I3. For a multi-phase 5-year project, did the developer apply for first plat in accordance with Hayden Code 12-3-4I3 and consistent with MDA 2.2? Is the plat application for the first plat due within 2 years? Please reference my previous answer. Did city staff approve the developer's best management practices or establish a joint management agreement with the adjoining property owners to allow the developer to drain stormwater off-site onto adjacent properties? Stormwater drains from the site today. Performance standards are identified in Hayden City Code 8-3-6, which identify that the following performance standards shall be applicable to all design, construction, and implementation and maintenance of stormwater management systems pursuant to the jurisdiction exercised through this chapter, specifically with respect to rate of flow, collection of concentration, and directed to infiltration areas. The MDA allows for 66 single-family residential building lots. The latest construction document includes 69 building lots. How and when was the increase in number of building lots approved? As I've stated before, the preliminary plat request was for 72 lots. City Council's deliberation, condition of approval, written decisions did not reduce that number. Therefore, the number referenced on page 1 of that master development agreement is believed to be an error. The master development agreement Exhibit A, site plan, illustrates public park open space tract A on top of the hill with accessible trail and picnic tables. Building lots leaving only the steep west hillside looming above the backyards of the Emerald Estate residences have displaced this accessible park with amenities. How and when was the removal of accessible park approved? As was identified due to the configuration changes related to the coordinated participation with the developer to the north and the infrastructure requirements of the subdivision, it was identified in condition 18 of the approval that the park configuration may be slightly different and was allowed as long as connectivity was met with respect to from Stone Creek and the south of Lancaster and the bicycle walking ways to the north. Also, condition 19 of the master development agreement also allows staff to determine if the revisions are substantial or minor. That determination is made by our city engineer. Our property is adjacent to the area where the trees were removed. We've experienced slumping of our retaining walls and the adjacent ground. What remedies do I have to repair the damage? This is a civil matter, and the city does not provide legal advice to citizens regarding civil matters. I have concerns regarding the wastewater and rain runoff that will be increased by this project. What is the plan for this water? And is it still being allowed to be funneled to the pond and creek behind the houses on Maroon Creek? If so, who would be responsible for the damage due to the increased flow? Wastewater, by definition, is related to sewer and is going to be addressed in the construction plan review. All the stormwater issues are addressed during the construction plan review. And as I mentioned, the city approved stormwater plan. In light of the new information that we all now have about the wetland on the Stone Creek North property, the potential for flooding both on-site and downstream, shouldn't the wetland be preserved and the development scaled back to address these issues? We are not sure what the new information is. We received no requirements from any agency to protect these wetlands. How is the city of Hayden planning to address the potential for groundwater contamination, since this wetland drains directly into the aquifer that supplies drinking water for our community and many others? Stormwater drains from the site today. Performance standards are identified in City Code 8-3-6, which identify what the following performance standards shall be applicable to all design, construction, implementation, and maintenance of stormwater management systems pursuant to the jurisdiction exercised through this chapter, specifically with respect to rate of flow, collection or concentration, and directed to infiltration areas. That is one sentence. That will be changed in the information we put on the website. What is the city's plan to ensure that the laws and regulations regarding traffic and street safety are followed with respect to this new project? Those requirements are covered in the construction plan review, and the developer must conform to them. The original master development agreement presented at the public hearing was the last one presented to the communities. What process has been used to make changes to the original preliminary MDA, master development agreement, neglecting the neighboring communities, denying us with a public hearing? No changes have been made either to the MDA nor the conditions of approval. Has the traffic study been updated for the, let me rephrase this. Has the traffic study been updated to include the Maple Street subdivision and the Hayden Canyon development? As traffic increases on Government Way, we are sure that some of the overflow will end up at Rocking R. The applicant was required to provide a traffic impact analysis at the time of application, as required by Hayden City Code, and that analysis was used by the City Council in their decision for this project. The original master development agreement has a traffic calming T intersection on the extended Rocking R Road as part of the new development, now having been eliminated. Note that the current length of Rocking R Road is currently approximately 3/4 of a mile long without a stop sign or speed bumps. With the addition of Stone Creek North and Marks developments, not only will this road have more traffic, but it will also extend the length to about 1¼ miles long. This is a serious safety concern to our community. What measures are being implemented to control the traffic? During the construction plan review, the plans will be reviewed for compliance with city codes, plans, and policies with respect to other agency comments. On a personal note, I believe you can also expect to see traffic controls on Rocking R Road. As the building department will be responsible to oversee the construction of the wetland, what measures is the city taking to address the overflow of the stream at the east side of the existing Stone Creek and Rocking R communities? The approved construction plans for the subdivision will address stormwater for the entire site, including future building sites in what was a non-jurisdictional wetland area in accordance with Hayden City Code. The approved construction document shows 69 lots. The MDA Exhibit A site plan allows 66 building lots. Is this accurate? If yes, can this occur without a public hearing? The preliminary plat request was for 72 lots. This is believed to be a typo on the Master Development Agreement, page 1, because the written decision of the City Council did not reduce the number of lots from what was originally proposed. We look at the original site plan in the Master Development Agreement, Exhibit A, and saw that it shows a public park in open space Tract A that has a path and picnic tables at the top of the hill. Now, in the staff-approved construction documents, building lots displace this portion of the park, leaving only a steep hillside. Will there be a park incorporated within the Stone Creek North subdivision that is ADA accessible? Yes, a portion of the park will be ADA accessible. The staff review identifies this park as a specialty park, recognizing its unique terrain as one of the benefits of this park area. Bicycle and pedestrian connectivity between the park in Stone Creek to the south and the bicycle and pedestrian pathway south of Lancaster, which includes the park to be in Mark's Ranch, is identified in both the long-range plans. On the original site plan in the Master Development Agreement, Exhibit A, in the southwest corner, there is a traffic calming T intersection that connects southward to the Rocking R Road. In the staff-approved construction documents, this is gone. It's replaced by a direct thoroughfare. We fear this will increase traffic speed on Rocking R and create a safety concern for our residents. Currently, Rocking R Road is approximately 3/4 of a mile long without a stop sign or speed bumps. Extending this road to Lancaster would increase it to approximately 1¼ miles. Please describe what process allowed this change without a public hearing. Condition 19 of the written decision allows revisions to the plan. Under City Code 12-3-4H2, the city engineer determines whether or not these revisions are to be considered major or minor. Minor revisions do not require a public hearing. The MDA Exhibit C Conditions of Approval is based on a second emergency vehicle egress northwards towards Lancaster through the Marks Ranch, which does not currently exist. Has there been a change to the 2020 Council's Conditions of Approval? If not, how can the development continue? No, there has been no change. The project will develop in accordance with its approvals. That's it.
Two more on the back.
Everybody, yeah. Let's get a round of applause for that, okay?
Mr. Mayor, you have 2 more on the back.
Sorry, John. Sorry, folks, we have 2 more. With regards to traffic impacts, the conditions of approval are based on an outdated traffic study, the ITERA study, April 30th, 2020, that only includes Marks and Stone Creek North. We now know that traffic flow in our area will be exacerbated by Hayden Canyon, the new Maple Street subdivision north of Honeysuckle. In addition to the general traffic increase we have all experienced these past 2 years, can the city still commit to this traffic study as adequately addressing the safety of our community? The applicant was required to provide a traffic impact analysis at the time of application as required by city code, and that analysis was used by city council in their decision on this project. We know that at least 25 building lots are planned in mapped wetland and flood zones. During the public meeting prior to conditional approval, council members expressed concern about the wetlands, flooding, and the stormwater impacts. The wetland is an important component of the natural stormwater system. Why didn't the city exercise its ultimate statutory authority to require the developer to study and protect this sensitive area and require a downstream analysis of the stream that affects 30 residential properties in our respective HOAs? On advice of our legal counsel, the appropriate time to bring up additional studies was at the time of approval of the preliminary plat. No agencies provided a requirement to protect the non-jurisdictional wetlands. Additionally, no agencies identified this area to be within a flood zone, more specifically the FEMA and the FIRM map. FEMA is the Federal Emergency Management Agency, and FIRM is the Federal Insurance Rate Map. As a result of the comments received from the agencies, the city had no basis to require additional studies. Now I'm done. At this point, folks that have follow-up questions, we would be happy to entertain them, as I mentioned, to the extent that we can. If we can answer those questions here tonight, we will. If it requires digging in the record or legal analysis, we'll have to put that off and get the answers back to you later. If you have additional questions, please raise your hand. I'll call on you. Please go to the podium and state your name and address. Yes, sir.
Mayor, while he's walking,
Yes, sir.
will our council members have an opportunity to share their thoughts as well?
No, that would be outside the public process. They're here to observe.
So my name
I'm
is,
asking the mayor that question, not you.
I know, and I'm answering for him because he would have asked me.
Mr. Akiyama, it's what she says.
my name
Mr.
is Rick. I live
if you go in front of the microphone there, and sir.
My name is Rick. I live.
Rick, just to remind you, this is for questions, sir, and not comments.
Going to ask one.
Thank you. Go ahead.
So why is it that you're not addressing the letter from Idaho Fish and Game from Mr. Corsi that recommended protection of the wetlands?
Actually, I believe we answered that tonight.
I don't recall hearing it. I'm sorry.
Okay, that's all right. I will get you that information again, but I did answer that earlier this evening. You know, there were enough questions that I can certainly understand where one might have slid by you. Yes, ma'am. Sorry, I know it's a long walk. And if you give us your name and address, please, ma'am.
Sure, yep, it's Brenda Patrick, and I live at 1240 East Maroon Creek Drive.
Thank you.
Yep.
Go ahead.
And I'm just curious what a specialty park, if you could define what a specialty park is.
Great question. Donna, can you define what a specialty park is?
It's on the website, but a specialty park is a park that has unique characteristics. For specific guidance as far as what is in a specialty park, it's under the Imagine Hayden tab under the park plan in the appendix, and it kind of lists the components of what could be in a specialty park, but it helps recognize areas that are not your traditional flat sports complexes, but more related to unique characteristics of certain areas.
Do you know?
I-
You don't
I don't know at this point, but there are certain components that are required that were identified in the staff review at the time of the application.
And Ms. Patrick, your question is a good one, and we will provide more information on our answers at the website that we have for this meeting tonight. Thank you. Yes, sir.
Eric Edgar, I live on Rocking R Road, right next to Stone Creek North. I'd like to ask the question, the Stone Creek North construction plan that I saw eliminated 2 T intersections, not just one. The one that goes from Rocking R to Road A is 1 T intersection. And then there was another T intersection from Road A continuing up Rocking R. That's been eliminated. How is, and the road that we have now is just kind of snakes around more or less in a directly up to Mark's Ranch. How is that not a major change?
Excuse me. When the city council determined that there would be a full public road up to the southern boundary of Mark's Ranch and eventually up to Lancaster, that road could not be put in without making changes to the plat that was submitted. In order to make that road work, and given the elevation changes, those changes had to be made. That allowance for changes in the road was specifically identified in the master development agreement. It was the determination of our city engineer that the change made reconfiguring the road, if you will, was not a major change to the master development agreement, and it was completed by staff. Fonda or Donna, do you have anything? No. Okay. Questions? Okay.
Yeah, to be honest with you, I'm kind of upset about all this kind of stuff. So, I'm Ray Drexler. I go by Ray. Legal name is actually Horse, but I go by Ray. I live right on Rocking R, and this runaround right now, this crap about the, I'm sorry, I'll take it back. This issue about eliminating the T intersection, as far as everybody on Rocking R and the neighborhood of Stone Creek and Rocking R, they're the ones that are really being impacted here, and it's a huge safety condition. We have children, we have pets, and you guys are ignoring this. You should be standing up, and you're a neighbor. You talk differently now that you're mayor than when you were on the board for Stone Creek. Now, I live right on Rocking R. I'm the Rocking R HOA president, and I'm here representing my people, not my constituent, well, whatever you want to call them, and we're all upset about this. We're talking about a safety issue that's totally being ignored, and when you think about all these kids and all these pets on Rocking R right now, we're dealing with
Sir, I need you to ask a question.
Okay, how are you going to eliminate the problem? How's that?
Can I ask a question? That's a great, well, okay, thank you.
Right?
Thank you for
We're
your
going to need
question.
stop signs, obviously up here because of the snow plowing, we can't have.
Sir,
Okay.
let me answer your question.
We need an answer, and we need an answer before all this crap stops being talked about.
Sir, questions only tonight.
Okay, give us an answer on how to protect our kids and our pets.
Sir, you asked your question. Thank you.
Well, take it seriously.
Okay. First of all, I don't live in Stone Creek. I never lived there. I live on the other side of Highway 95.
Okay, well then apologize for the
It's okay.
misstatement.
I'm kind of on the other side there.
Well, you gotta come over to our side.
Literally.
And check out the traffic.
I completely get your concerns about increased traffic and particularly speeders on Rocking R Road. I completely get that.
And eliminating a T intersection is major, not minor.
During the construction phase of the review of these plans, we will be taking a look at what type of necessary intersection modifications or traffic controls we will be taking. I and I think every member of this council completely get where you're coming from. No, sir, there will not be a public hearing.
Can I ask a question?
Perfect.
Can I ask a question? I guess the mayor.
You can ask the mayor a question.
Okay. Will the city be able to look into and most likely provide speed mitigation devices as this moves forward? Like, if it is seen that there are speeders and issues, will the city be able to place stop signs or some form, whether it's at an intersection or not, but some way of mitigating the speed concerns?
Yes, sir, they will. Yes, sir.
Mike Vielle, I'm at 1404 East Maroon Creek, which means I'm right next door to the new development. But on Maroon Creek, which I expect will be less traffic done than Rocking R. At any rate, you said that essentially you can have there were 5 lots per 2 acres. That was, or you said 2.5 lots per acre is what the design, what the property would allow. I assume that means that all of the unbuildable area is counted in the total amount of acreage that's considered. And that's why so many very small lots are available for building. And so much of the other land that is non-buildable is put into is this supposed park that people will not have great access to.
Sir, do I hear a question in that?
Well, is that how the 2.5, the 2.5 lots, is that how that is figured? So all of the unbuildable land is part of the acreage that's considered for the properties.
I would have to go back through this and.
The
Yes,
annexation
ma'am.
agreement identifies that the density for the property would be 2.5 acres, 2.5 dwelling units per acre. That's gross acres.
How calculated?
Gross acres. Gross acres.
So the parkland is included
It is.
in that calculation. Okay, thank you.
Okay, thank you very much.
sir,
That was my question.
And to just further, the lots on that map do look small, but they meet all of the single-family residential criteria, even what looks small.
Yeah, I understand that the legal, what was minimum approval requirements were met by this property.
Yes, sir.
But unfortunately, it's the minimal requirement is what was met, and that's what the previous council and the planning department basically let it go through. I was just hoping that the council would step in and do what's right rather than what's...
Sorry, sir.
I know.
Bordering on a comment.
Can I make a
Thank you.
suggestion?
Hang on just a minute
You're
here.
lining
Let's-
people up because we got
let's
hands
just-
going up.
Yes, ma'am.
Louise O'Brien, 12905 North Emerald Drive.
Thank you, ma'am.
Retired military of 20 years and 15 years of service to the state of Idaho as a deputy sheriff.
Thank you for your service.
I have lived on Emerald 35 years. I would like to ask you about the pump house outside my fence, 50 yards from my house, and also the access road to the side of my house that was supposed to be a fire exit. What is the truth?
That's a great question that I do not have an answer off the top of my head for, ma'am. Can we, do we have a,
It's not related to the subdivision. The project site plan that she's referring to is not related to the subdivision.
So I'm going to have to listen to the pump house.
I'm aware of that, but what I'm saying is,
And the
is that it's not
generators.
related to the subdivision approval. It's a site development project.
ma'am,
Yes, sir?
if you would stop by City Hall here,
I'd be happy to.
I will be happy to make sure that you get
Yep.
as many answers, as much, and I know that you're in the county, you are not in the city.
Yes,
But we
and
will
that's
give
the
you-
problem.
we
They
will-
say we're county, and on the other side of my friends is city. And we have two different rules. Am I going to have to sit on my back porch and listen to those generators and water pumps 50 yards from my house?
If you will come by City Hall, I will get an answer for you to that question. I just
will
don't
be
have it
there,
off the
sir.
top of my head.
I will be there, sir.
Okay. Yes, ma'am.
Amy McCamley, Rocking Our Housing Community. So a couple of questions. Have all of our city councilmen and mayor, have you been to our neighborhood to see the construction site, to see everything that all of us are bringing up concerns about?
Are we allowed to answer that?
Are we allowed to answer that?
You can answer that.
Yes,
I'm familiar with it, yeah, I've
I
been
am.
up and around there, sure.
yes, yes.
Okay.
I live in Rocking Horse, so
Yeah.
yes, I'm your neighbor.
So you know the concerns. Okay, then the second thing, you might have answered this, I might have missed it. When is the construction starting? That's going to interfere with all of our neighborhood?
Okay. We can't tell you when construction starts. We can only tell you when the final plat will be approved. Once the final plat is approved, the developer does not have, other than providing the infrastructure, as far as construction, we cannot give you that information. We don't have
Mr.
it.
Mayor, just one point of
Yes,
clarification.
ma'am, go ahead.
So once all of the conditions of approval are met, the applicant will be provided with a notice to proceed the construction of the infrastructure. Because remember, the infrastructure is constructed previous to final plat coming to you, because when you approve final plat, you're accepting that infrastructure. So just a little point of order on the timeline of that.
Okay. Thank you.
So when does that, I have a couple more questions. So when does that start? When is that?
They're in the construction approval phase right now, but the notice.
And we don't know when it's gonna be finally
Notice to
approved?
proceed has not been issued.
And we don't know how long that's going to take?
I don't know.
And then once they start, do they have a timeline of when they have to finish? Or can our neighborhood just be torn up for however long they feel like taking?
I don't have a question to that, answer to that question either. I will get an answer to that question for you, and I will make sure it's on the website.
And then are there,
To the extent that
So,
we are.
Mr. Mayor,
That we are.
according to their master development agreement, they have 5 years to final plat their final phase, unless they receive an extension for council, so.
Okay, so
so the interruption in our neighborhood of construction trucks going through can be up to 5 years?
is that correct?
From the time that it was approved.
From the time that it's
Unless
approved?
extensions are granted.
So 5 years?
Unless extensions are granted.
But 2 years in a row.
Okay, so minimum 5 years, we're looking at our neighborhood being torn up with construction trucks going through?
It's 5 years.
That's what we're saying?
2 years have elapsed, right?
Correct.
So we have 3 years.
So 3 years.
So 3 years left, okay. And then are there hours and days of the week they're allowed to be working and driving their big trucks through the neighborhood and chainsaws and all that good stuff going on?
As we found out during the logging operation, yes, there are permitted hours of operation.
So what are those hours?
I am unfamiliar with permitted days of operation.
7 days a week.
Okay, but there are permitted hours of operation.
So 7 days a week. And then the hours we need to get an answer on.
I'll have to find out what the hours are for you, but I remember from the logging operations that
Right,
I did know at one point.
okay. All right.
Thank you. Ma'am, go ahead.
Those simple ones just not.
Mr. Mayor, really quick.
Yes, ma'am.
Title 4, Chapter 1 talks about noise standards. So on weekdays, they can work from Monday through Friday, they can work from 6 a.m. until 9 p.m. And on the weekends, they can work from 7 to 9.
Okay, thank you. Yes, ma'am, the question.
Susan Lehman. I live on Hayden Avenue. And I noticed that there were multiple questions asking about why aren't the wetlands being protected? And I noticed that for each of those questions, the answer was, none of the agencies required protection of the jurisdictional wetlands. So 2 questions, and I'll ask them both and then wait for a response. One, what is a jurisdictional wetland versus a non-jurisdictional wetland? 2, it seems like, so these are agencies, I'm guessing, in Boise and in DC, both, correct?
No.
Just Boise?
They're local.
The agencies that we're talking about, the Army Corps of Engineers has an office here in Coeur d'Alene.
Okay.
Coeur d'Alene. And Idaho Department of Environmental Quality also has an office in Coeur d'Alene. So they are obviously the Corps of Engineers, a federal agency, but their office is here. So these are local agencies.
In any case, if there's no requirement to protect the wetlands, and that's good to know, it's good to know where you are, regulation-wise, but that doesn't make any statement that you can't require protection yourselves. So why not go ahead, go a step above, and do what clearly your constituents want you to do?
The right thing to do.
So the Army Corps of Engineers has jurisdictional authority over all, yes?
I gotta add to this.
Is it a question? Is it a question?
Sit down.
Questions.
Sir, sit down.
Okay, then I
The lady still has the podium. Sit down, sir.
So for those of you that have reviewed the record, you've seen the letter, it's in here 3 or 4 times from the Army Corps of Engineers. So the Army Corps of Engineers has federal jurisdiction over wetlands. So when there's a property that's coming forward to develop that has a wetland on the map, the applicant or the property owner goes to the Army Corps of Engineers and they say, I need a wetlands delineation report. And the Army Corps of Engineers, they come out, and they came on site. If you've read the report, you'll know that they reviewed the public records, they talked to the applicant, they came out on site, and they reviewed the wetlands, and then they issued a determination. And when they issue that determination, it's called a wetlands delineation. And they say, either we have jurisdiction over these wetlands because they are a wetland that needs mitigated in order for development, and then they would issue a 404, what's called a 404 fill permit to the applicant. So they would either say, it's a wetland that we have jurisdiction over and you're not going to develop it. It's a wetland we have jurisdiction over, but it's already been modified and it's still going to require some further mitigation. And so you need to apply for a 404 permit. That's what it's called. And then when that happens and they issue the 404 permit, within that 404 permit will be all of the requirements for the applicant to do anything related to development around this wetland. In this particular case, the Army Corps of Engineers determination was this is a non-jurisdictional wetland. And I think that is a brilliant question, because we rattle these terms off like everybody knows what it is, and it's not fair. So by them saying it is a non-jurisdictional wetland, they're saying we don't have jurisdiction over this wetland, and we're not going to require any mitigation, and we're not going to require any fill. You don't need a fill permit, and you don't need to take any mitigation measures from the Federal Army Corps of Engineers perspective. And so that's what we as a city, and that's what our code says, that we have the right to rely on that information from the Army Corps of Engineers.
Not accurate.
In any event, the record, for tonight's purposes, it's what's in the record and what happened leading up to this written decision in 2020. So that's just an explanation of the jurisdictional versus the non-jurisdictional. And this was, if you go through the record, and unfortunately I've had the joy of memorizing it, it was brought up during that time period. And there were people here who came out robustly talking about the wetlands and their objections, and the project was approved and it wasn't appealed at that time. So I hope that answers your question on the jurisdictional versus the non-jurisdictional.
It does answer my question, so thank you for clarifying
You're
that. I
welcome.
appreciate the clarifying. It strikes me that if the federal government doesn't have jurisdiction, that's like, yay, then we locally have even more authority. And then it seems even further that if your constituents are saying something very clearly that they're concerned about, that again, it's the same thing. The Hayden Code, it seems like you could go above and beyond and say, okay, but we want to do this because this is what the constituents want.
Wanda?
Yes, sir.
See if I can word this in some way or another, maybe.
Is it a question?
It is a question. It starts with does. Does the city have any code or ability to prevent building on the wetlands without exposure to litigation from an applicant? Like you say the reports say the Army Corps of Engineers and all that say, we don't see any reason why you need to. Is there anything that if the city were to say, okay, we're going to stop you, applicant, even though all these other entities don't seem to have an issue, where the applicant could then come back and say, you don't have a right to stop.
We don't have a mechanism in our code for
That's
that.
my question. Do we have a mechanism?
Specific to wetlands, we do not have a mechanism in our code
And
for
if
that.
we, without having that mechanism, did try and stop the applicant, would we be exposed to I don't know.
The applicant always has a right to come back and make a claim for a regulatory takings analysis. So that's when we talked earlier about the due process rights of each side and the private property rights. So if any applicant, not particular to this application, but if the city council in its decision puts a requirement on the applicant that is in excess of what is required by our code, that is the applicant's recourse, is to come back
That's my
and
question.
have us provide what's called a regulatory takings analysis.
And we do not have a mechanism, so they would have that.
We don't have so there was not and is not a wetlands mechanism beyond relying on the jurisdictional wetland delineation from the Army Corps of Engineers.
That's kind of what I'm asking.
And/or other comments from other regulatory agencies related to wetlands.
Such as the Idaho Department of Environmental Quality.
Correct. And for clarification of the record for IDEQ, and it was answered in the question, DEQ came out in response to the planning and zoning notices and said they wanted a further study done. They did. That's in the record if you look at it. And then when it came time for council and they received their second agency notice, they realized that an Army Corps of Engineers wetlands delineation report had been provided and they withdrew their request. So it's not just that DEQ didn't request it, they withdrew their request before council. And that's what council was left with at the time of making this decision, is that record.
Yes, sir.
My name's Todd Brumbach. I live at 10831 Rocking R Road. intersection of Lacey and Rocking R. I believe when you were talking about agencies' responses, you said that the Idaho DEQ was still in the process of a particular review, and that was the only one. So are you saying also that that's inconsequential and does not impact the beginning of this construction?
Good question. No, sir, that is not what I'm saying. If Idaho DEQ or Northern Lakes Fire Department, Fire District, have concerns, remaining concerns, upon reviewing this final plat, the plat may be altered.
Construction drawings.
Pardon me, thank you, the construction plan may be altered. So those two agencies, we have still not heard from, and they could affect the outcome of this.
Okay. May I ask a second question?
Certainly.
You repeatedly had to address the question about the road from Lancaster in, with no specific timeline other than kind of a vague response that it was going to be somewhere as construction progressed. Is there a time, a date at which that can be enforced so that that road is built?
Good question. Don or Fonda, are you familiar with the development plans of Mark's Ranch and when we might be able to?
We cannot comment on Mark's Ranch here tonight.
Okay. No, sir, I'm afraid I can't provide you a date on that. We encourage those two developers to get together and allow at least a construction access road through there, but as I mentioned several times, we cannot require it.
There is a condition of approval that speaks to that.
Okay. Yes, sir.
Mr. Mayor, my name is Thomas Schaefer. I live in Rocking R Road. First of all, I apologize for my outburst. You can tell a lot of us care deeply about what's happening here. So this issue of jurisdictional versus non-jurisdictional wetlands, you know, this has to do with the fact that our previous president said, let's get DC out of the way of local issues.
Sir, I need to have a question.
It's going to end in a question, I promise you. You obviously see how much people care about this, and I'm sure everybody here acknowledges how important this is to the local environment here. My question is, are you really serious that you are going to rely on a lack of response from regulating agencies rather than do the right thing? Thank you.
Thank you. Yes, sir. Mr. Akiyama, if you'd pause that for just a moment. Thank you. The two agencies that have regulatory authority over those wetlands are the Corps of Engineers and the Idaho Department of Environmental Quality. Both of them did respond. Mr. Akiyama, I'm sorry, could you give your name and address, sir?
Mr. Akiyama, resident of Hayden. First of all, thank you for scheduling this special occasion. I know you all are busy, staff are all busy. We thank you so much for doing this special session on behalf of our neighbors. Thank you, Councilman DePriest, for giving me a clue on how to state fact as a question. I'll start with a does or a did. Now and thank you for not limiting us to 5 minutes. This dynamics of asking questions versus stating a fact is a challenge for my old brain here.
Well, you know I will ask you to separate those, yes.
Pardon me?
You know I will ask you to separate those.
And I lost my notes as I just simply walked up here. Okay, anyway, bear with me, it's coming. does the master development agreement include the written decisions, the condition of approvals of the 2020 council, all the way through the construction documents up to the point of the construction improvement agreement? As I understand it, that is the confine, the bookends of tonight's questioning.
No, it does not.
It does not do what?
It does not contain that.
Okay, let me rephrase the question. Does it contain, the master development agreement defines Exhibit C as part of the agreement. Exhibit C contains the public hearings of both P&Z and the city council, the written decisions, the factual basis of history, the conditions of approval of the 2020 council, as well as the process of developing the construction documents. That's my understanding of what the bookends are for tonight. That's a question, by the way.
I'm seeing an affirmative, yes, sir.
Thank you very much.
Okay.
But not, it's the same.
Right, it's, the Exhibit D is a template for the construction improvement agreement, so that the,
You're right, I didn't say D, I said C, Exhibit C.
I was just clarifying what was in the master development agreement.
Okay, now, let's see. Did I'm trying to de-escalate this all with a little humor here. Did the 2020 council, no, let me rephrase, I'm going to say was the 2020 council involved with the public hearings and therefore the conditional approval of the preliminary plat?
Yes.
Thank you, sir. Therefore, I shall ask two council members present tonight for your forgiveness in advance because I'm struggling with how to turn fact into a question. The 2020 council, therefore, did the 2020 council include Council Member Satterfile, who was at that time the president? That was a question.
Yes.
Did the 2020 council include current President Councilman Roeder?
Yes.
Thank you. And council members DeLange, Panabaker, they're not with us tonight, but they were part of the 2020 council, correct?
Yes.
Thank you. Then Mayor Steve Griffiths recused himself from both the P&Z hearing and the council hearing and graciously joined the audience, correct?
I do not know that. I believe that is correct.
That's what the minutes reflect.
Minutes of the meeting say that is correct, yes.
Thank you. The options before the 2020 council, now here's my forgiveness in advance because you two were there. I think, that's a question, I think.
No, that's a statement.
No, sir, that is, no question.
Were the three options of decisions that the 2020 council had were either approve the preliminary plat or approve the preliminary plat with conditions or deny the preliminary plat. In my understanding, that were the three options of decision-making, correct?
Were those the three options in 2020?
I don't have that. I can pull it up, but generally, yes.
I acquired that from the city's timeline guidelines on minor and major subdivisions. I think I did. That's a question, I guess. I don't know. So therefore, am I correct in saying that the 2020 council approved the preliminary plat with conditions? That's a question.
I would have to look at the record, sir. I can't answer that right at the moment.
In the public record that is included in Exhibit C, the council's conditions of approval, there's a heading that says conditions of approval. And there are 23 points behind the heading conditions of approval. Following that, there's another header paragraph, if you will, that talks about the project duration, of which there are 8 specific points regarding the timeline
Mr. Mayor, I
requirement.
think
So
we
my
are-
question is this, is
we are
that it was a
dangerous.
condition of approval.
We are in dangerous territory regarding public comment. This time is for people to ask questions that have not already been answered and to ask them in a question form without comment.
I disagree with that. This is not a question that was not, this is a question that was not asked.
I didn't say your question had been answered. I said just make sure that the questions you're asking are some that have not been answered.
It was a condition of approval. 2020 council approved the preliminary plat as a condition of approval.
What is your question, Mr. Akiyama?
That it was a condition, that the council approved the preliminary plat with conditions. Question mark.
Okay?
Okay, I'll take okay as a yes. Okay, thank you for your tolerance with me.
To the best of my knowledge, yes. Sir. But Mr. Akiyama, I need to have you ask questions.
I thought I was.
Keep going.
That was a question too. I thought it was. Okay, therefore, having established these, the answers to the questions I just asked, regarding the wetlands, during the conditions of approval, did the conditions of approval state certain council members, i.e. then President Councilmember Satterfeld, as stating that drainage, wetlands, etc., shall meet all applicable codes? Was that included in the, it was, but I have to turn it into a question.
Council members do not have to answer any questions. These questions are directed at the mayor.
I'm the lucky guy.
You're the lucky guy. However, you're kind of coordinating the council members, so. Allow that to stand as a question that's to be researched later then.
What's your question again, Mr. Akiyama?
Okay. The conditions of approval, did the conditions of approval, did President Councilmember Satterfeld state as a condition of approval that the wetlands, drainage, and a few other items shall meet the codes, it said all codes, question mark.
Where's the condition?
I do not know that, but I suspect the answer is yes.
Thank you, sir.
That's correct.
Let's see here. Does the City of Hayden Code 12-3-4, 19D address sensitive areas, including wetlands, groundwater, and floods?
Is that where that portion of the code? I don't have a idea of the codes.
So we'll let that stand as an outstanding question. Yes?
We'll get you an answer. Yes, it does.
Thank you, sir.
We're still trying to carve through the question related to the conditions of approval because no council member specifically puts makes a condition of approval. The conditions of approval are part of the overall decision that it's approved by the entire council. So that, we were still on that question, so I apologize.
Does paragraph, I believe it's in section 1 of the MDA, no, that was toward the end of the MDA, it defines which parts, does it not define which parts of the documents are a part of the MDA, namely exhibits A, B, and C. So that was an earlier question a few minutes ago. I'll let that stand. Okay. I apologize in advance, I don't want this to turn into a courtroom hearing style of questioning, but since we're only allowed to ask questions. Did Idaho Department of Environmental Quality send a staff member to meet with you, Mr. Mayor?
Yes.
To clarify that the city of Hayden is the decision-making authority regarding wetlands.
Mr. Mayor, those questions are outside the record.
Mr. Akiyama, those questions are outside the record. I'm afraid I can't answer that.
Because the record ends at the master development agreement.
I asked that question in context to the answers given tonight repeatedly about no agencies have given directions or required further study or protection of the wetlands. And therefore, my question is this, is that DEQ has stated that the city of Hayden has the decision-making authority over the wetlands, therefore should apply the sensitive areas City of Hayden Code 12-3-419D. Okay, I'll move on.
Was there a question there?
That was the question.
No, sir, I'm sorry, that was not a question. I need you, please, Mr. Akiyama, we are in legal framework here. You need to be asking questions.
Okay, I'll rephrase it. Is the city of Hayden the decision-making authority to decide to apply the sensitive areas City of Hayden Code upon the applicant, the developer?
At the time of this application, the city code was applied and all reports that were required were provided.
How do I
through the process.
Debate that with a question?
You can't hear it
You
tonight,
don't,
sir.
it's not a debate.
Okay.
Not a
It's
debate.
not? You all heard that. Regarding stormwater, the stormwater management question, has the city approved best management practices, BMP, to allow the stormwater from the development to run off-site onto adjacent neighbors' property?
I believe the answer to that was in the
We answered that question already, Mr. Akiyama.
The BMPs? So a BMP has been approved?
We answered that question earlier tonight.
Okay, I'm sorry. I asked
Maybe
again,
not
I
to
didn't
your
hear it.
satisfaction, but we did answer that question.
So BMPs have been approved, question mark?
We already answered that. It was in there.
What was the answer?
The answer is stormwater. Okay, did city staff approve the developer's best management practices or establish a joint management agreement with adjoining property owners to allow the developer to drain stormwater off-site onto adjacent properties?
The answer was?
Stormwater drains from the site today.
That's not the question.
Pre-development.
It's not the question.
Performance standards are identified in Hayden City Code, which identify the following performance standards shall be applicable to all design, construction, and implementation and maintenance of stormwater management systems pursuant to the jurisdiction exercised through this chapter, specifically with respect to rate of flow, collection of concentration, and directed infiltration areas. That was the maybe longest sentence I've ever said.
But that was your answer?
Yes, sir, that's my answer.
All right. We are not here to agree or disagree to your answers, correct?
Correct.
Thank you.
I suspect I know what your answer would be, but no, sir, that's not the purpose tonight.
The conditions of approval, which is part of the master development agreement, I would ask for clarification. Is that a question, asking for a clarification?
It's not, but
Did the conditions of approval specifically state that council will conditionally approve this subdivision with 66 lots?
pretty sure the answer to that's no.
Let's see now. Did Councilman Satterfile, you weren't there, but he was, so again, you're asking for your forgiveness in advance because of the style of this discussion. Did Councilman Satterfile state that we need to have the geotech engineers perform a downstream study and a study on drainage? Question mark.
I do not know. I will be happy to check the meeting minutes and let you know about that.
Thank you. Did Liberty Geotech report address downstream analysis and drainage effects?
I do not know. I will be happy to get you that information.
Thank you. I'm almost finished.
Okay.
Debbie, please. Okay. Given the closing statement on the signature page of the Master Development Agreement, of which I will read for purposes of stating the context of my question. With this decision, there are a number of conditions with specific components. The specificity does not preclude the city from exercising its right to require compliance or demonstrate compliance with any condition at any time, as well as any other applicable requirements, whether or not specifically articulated herein. Is it too late to intervene and correct the trajectory of this project based on that clause in the MDA?
We are awaiting review from 2 agencies.
Where are they?
That's
Northern
construction phase information.
You already mentioned it.
Okay.
You already stated it.
That is review of construction documents information, not construction phase information. Northern Lakes Fire Department has not reviewed the
That's a
current
comment, not a
construction
question.
document
Is there a question there?
review process. Therefore, is it approved? That's my question.
Northern
Lakes Fire District.
Are you asking,
Have they approved?
has Northern Lakes Fire Department approved the preliminary, the final plat? Is that your question?
Has Northern Lakes Fire Department approved the construction documents?
No.
Thank you, sir.
Okay.
Thank you very much.
You're welcome. Thank you for standing up there tonight. It's a challenge, but thank you.
Yes, it is, isn't it?
Other questions? Yes, sir.
Mine will be quick. Brad Cravens and I live in Arena Loop in Rocking R.
Yes, sir.
Many times tonight, it was referenced to getting evaluations, assessments, whatever, for be it traffic assessments, environmental, whatever. When those are done, is that done through the contractor, or does the city of Hayden do that independently on their own?
That is a good question. The city has its own consultants that it uses. The costs of those studies are borne by the applicant.
Okay, so you all do them yourself then?
Yes, sir. No, sir.
I mean, you contract to have them done?
Yes, sir.
By your own people that you pick, and it's not the developer doing it?
That is correct. Yes, sir.
Okay, thank you.
Include the traffic study?
Mhm.
Said earlier that applicant did that.
Pays for it.
Other questions? Yes, sir. I'm getting to know you folks by the questions that I was asked and answered tonight. Yes, sir.
Good afternoon, good evening, council, and thank you for this opportunity. I've got two questions for you very
Sir,
quickly.
would you please state your name and address?
Excuse me. My name is Kenny Moore. I live on East Hayden Lake Road in Hayden.
Thank you very much.
Apparently, since the Corps of Engineers declined to make comment about the things that we're concerned about the wetlands tonight, since they've refused to get into that issue deeply, do we have an office on the city government that specifically handles that aspect, that responsibility?
Generally, that responsibility is handled by our community development department.
Okay, thank you very much. The second one, does the owner of the Seven Lakes LLC live locally in Hayden?
I do not know.
Do you know where he does live?
No, sir, I do not.
We don't know if he's local.
No, sir, I cannot provide that information to you.
Thank you.
Other questions? Ladies and gentlemen?
Mayor?
Yes, sir. Mr. Roeder.
Since the public, and I want to hear from them first on their questions, but I have a few questions for the mayor, if I may.
Certainly. Go ahead,
No,
Ms.
you may
Roeder.
not. We're outside the public process. In the event that any sort of an appeal might need to come before you for a decision in the future, the whole purpose of keeping this contained is to try to protect you so that you can still maybe be involved at that point.
So if I ask a question that's on the record?
You don't have a decision point here tonight, so it's not appropriate to ask any questions, or you were just invited to observe, making sure that we answered the questions that were appropriate for the public. I guess if you want to ask your question, then I can say whether or not it can be answered.
So if I come in and sit down with staff, then the answer to my question, does it stay within the communication of myself and the staff?
Yes.
Council President Roeder, might I suggest that you ask your question and then
Then we'll decide whether or not.
can tell you what sort of legal jeopardy we become.
Oh. Yeah, thank you. So I appreciate everybody's patience here. Question is, has the has the Kootenai-Shoshone Soil and Water Conservation District been asked to review the plan for this development to make comment on it?
That's not an appropriate question. So at the time of public hearing is when those types of questions are appropriate to be asked. Or if you're in a de novo review, or you're sitting in a decision-making authority in a quasi-judicial hearing, that's not what this is.
Because I know the issue came up about what all these agencies been contacted. I'd just like to know if that one was contacted.
So we can publish a list of the names. It's in the record, but we can publish on the website a list of the names of agencies that were contacted.
Okay, so then the same question and answer will then be applied to the Cooney County Aquifer Protection District.
We'll publish the list of who was notified.
Okay.
And they are not a, they're not a, no, that's the right term.
Enforcement rulemaking.
Enforcement agency, thank you. But we'll publish the list of who was notified.
And then two other questions related to those. Do we know if the property owners within Stone Creek North or Rocking are they taxed by the Cooney County Aquifer Protection District?
I would have no way of knowing that.
Okay, we don't know the answer. Okay, same question applies to the Kootenai-Shoshone Soil Conservation District. Are those folks taxed by that taxing entity?
We would have no way of knowing that.
Okay, that's all I have. Thank you.
So then can you find out for us? We're answering all the different questions, getting follow-up answers?
I'll make a legal determination on that. That was exactly why council is not to be asking questions tonight.
Oh, well then can I ask that same question?
It was just asked. We will post a list of who was notified if we can find out how people are taxed. I mean, I wouldn't know how any one of you individually are taxed.
Nor would any of us.
You can look at your own property tax statements. Yes, absolutely.
Yeah, property tax statement would say it.
If you live in Stone Creek, it very well could be that you are being taxed, that is one of your taxing districts. We don't know. Yes, sir, if you'd like to make a question at the...
Okay, Rick Eitram, I live in Stone Creek. Point of clarification, the U.S. Army Corps of Engineers.
Mr. Eitram, I need to have you ask a question.
Okay, it'll come out as a question. Does the Army Corps of Engineers state that they have no jurisdiction because there are no navigable waters in this wetland? Navigable waters, that's the key issue. They did not say that they don't have jurisdiction over that way. Because there are no navigable waters, they do not have jurisdiction over those waters, therefore they declined to comment. But they did say that is a wetland.
Mr. Eitram? I'm sorry, sir, you're making comments.
All right.
I'm sorry about that. I'm going to have you sit down.
The other thing, did you receive a letter from the Idaho Fish and Game from Mr. Corsi stating that that wetland should be protected?
Yes, we did.
You did? You said yes?
Yes, you know we did.
Why did you not do that? When you say that you looked to the other agencies for guidance, you were given guidance.
The Fish and Game letter to the city said it should be protected, but provided no conditions or direction as to how to protect that.
Is that not because they do not have direct jurisdiction that they're asking you to protect it, to do the right thing, so to speak?
I cannot comment on their motives, sir. I cannot comment on their motives. They provided...
You had guidance from additional agencies, but it appears that they're being ignored. So I just thought it was kind of curious.
Thank you for your question, sir.
You're welcome.
Yes, ma'am.
Terry Switzer, I live on Hurricane Drive.
Yes, ma'am.
Of the agencies, you said that you were going to supply us with the agencies that were contacted, which is great.
Yes, ma'am.
Could we also, as kind of a piggyback onto that, find out which agencies responded?
Part of the record.
Yes, ma'am, that's part of the
Staff
record.
review published before the first planning and zoning public hearing. It's part of the record.
So there is a list of the agencies contacted and a list of the agencies that replied. Okay.
The responses in their entirety.
Yes. Thank you very much.
And to follow up on Mr. Eitram's question, I said this earlier tonight, but I will repeat it. Regarding the Idaho Fish and Game's letter, the Idaho Fish and Game did give us several conditions that they wanted to have adhered to. The city incorporated every condition that Idaho Fish and Game asked us to incorporate. And let me just finish reading this. The city incorporated all the recommendations of specific language to be included in the CC&Rs to be recorded at the time of final plat. Every request that Idaho Fish and Game made of us to be included in the conditions, the CC&Rs, is included. And that's included in condition 20 of the written decision. Yes, ma'am.
So follow-up question then, you just said earlier that there was no guidance given. So was there
There was a
guidance
what given,
given?
ma'am? I'm sorry?
So earlier I thought you'd said that there was no guidance given from Fish and Game, and that's why you weren't protecting the wetlands, because there's no
There
guidance
was
given.
no direction.
There was no direction.
The direction that Fish and Game gave us, we have incorporated. Fish and Game provided us no direction, no conditions. If you will look at that letter, you will see the conditions very plainly laid out from Fish and Game as to what they want us to do. We did it. We did everything they asked.
Did you not just say that you couldn't step in and protect anything because you were given no direction?
Fish and Game did not, in none of Fish and Game's conditions did they say anything about wetland protection. None of their conditions.
Okay, so then is that public record? How do we request their responses?
Of course, it's public record. Yes, ma'am, it's part of the record.
Okay, so yes, that's what we need to follow up on.
Mayor, I have one last, and I think we can answer this because it's a simple one. I'm just looking at the Stone Creek North written decision, and is in fact Holte 3 LLC the owner of the development?
Not today.
Who is?
Seven Lakes LLC. is
Seven
the owner
Lakes
of the property
LLC.
Today.
And do you know who the members are of that LLC? Okay, that's all I have. Thank you.
Yes, sir.
I just want to apologize for losing it, but the crappie deals are a huge thing for me and for Rocking Horse.
Thank you, sir. Appreciate that. Ladies and gentlemen, I believe that wraps, yes, ma'am.
One more.
Sure.
Susan Lehman, and this is a sincere question, I'm not trying to be flip. Why the obsession with questions? I mean, I'm asking literally, why does everything have to be a question? I can understand you don't want people to start just complaining and it just takes time and all that, but sometimes you even have to, you have to set up your question. So why can you not make a point at all?
So the reason for the questions was
Fonda, would you stand up
Yeah.
so everyone can hear you? Thank you.
to protect the fact, apparently I'm on mute. I apologize for that. I'm not very often muted. Because we are in a public process that is clearly defined by Idaho Code and Hayden City Code, and you are outside of that. The appeal periods have all expired. There's no legal mechanism as we sit here right now for this input or any comments to be provided to City Council for a decision-making point. But we wanted to respect the fact that you all had a bunch of questions, and you were presenting these questions in a variety of different ways to a variety of different people. So in the interest of trying to have all the questions answered at once, rather than all of these guys and all of these guys just being hammered from everybody else's questions, it was decided to do it in this format. But there's no legal mechanism as we sit here right now for any sort of a public hearing or public comment. Those periods are all expired. So that's why the form of a question.
Okay, and I
the
get
requirement that the questions be asked in writing ahead of time to the extent you could, so that we could have answers to those questions
Right.
rather than sitting here tonight and just going, well, we'll have to look it up. I don't know.
And I'm guessing that a lot of people here got their questions answered.
Well, we
I think
answered
some didn't,
everyone that was
but-
presented, and all 92 of them.
So, I get that plat preliminary approval has happened, appeals, I get that, and you guys can't make any decisions on that right now. But why does it have to be a question? Why can't people simply state their opinion or their objection or their support or whatever? With the knowledge that even no matter what you say, we can't do anything about it right now.
Because comment is more support, and in the interest of the quasi-judicial proceeding, the reality is, and the reason I was really careful with not letting council ask questions or answer questions or make comments is because technically this would be information provided to them that they shouldn't have, right? If there needs to be a decision point in the future, they're going to be tainted because of this process. So I'll tell you in all transparency, what will likely happen is that an independent hearing examiner will have to be hired in the future if there's any appeals or decision points or challenges that need to come back to this city on this project because of this. But in the interest of making sure that you guys got your questions answered, it was decided that this was a more streamlined process than all of the one-offs and the continued letters and emails and then I know that a lot of you took your time to come and make comment at city council meetings. And so that's not efficient either. Then you have a comment here and a comment here and a comment here. And so in just trying to give you an opportunity to get those questions answered, the special meeting was set up for that.
Okay. Well, that does answer my question. Thank you.
Ma'am. Yes, ma'am. You're the one I'm going to meet here at City Hall, right?
Yes.
There you go. Yes, ma'am, I promise, I promise. And could you give your name again, please, ma'am?
Louise O'Brien.
Thank you.
May I ask, these people live on the land that you're making a decision on. You represent the people of Hayden. Why are you not listening?
I'll consider that question rhetorical, ma'am. Thank you very much.
Just because there's gray on the head doesn't mean that there isn't a fire in the body. I was a woman Marine before I married an Air Force man. We served 20 years. Then I was a deputy sheriff. I listened to the people. You have to make a judgment, but the country says, we the people. Listen, you have 2 ears and one heart.
Thank you for your question. Ladies and gentlemen, thank you for sticking with us through this. I think I would rather have a root canal without anesthetic than do this again. We appreciate your attention. I hope you understand why we had the parameters we had to tonight. From council, may I have a motion for adjournment?
So moved.
Second. Seconded. Thank you, ladies and gentlemen. Meeting's over.
Thank you, everyone, for coming.